video, I'm going to take a look at one of the topics that people seem to have a particular interest in. It's one of two topics: defamation. The other one, as a matter of interest, is adverse possession. Irish people have a long lasting, enduring relationship with land, and the whole question of adverse possession is something that exercises them greatly, and I get a lot of queries about adverse possession. But this particular video that I'm doing now is about defamation, and it's something that comes up from time to time. People contact me regularly, whether they were defamed online, for example, whether they were defamed perhaps in an internal employment situation, whether they were defamed by reason of maybe an accusation or an allegation made against them in the employment context. So I came across a video or a case recently where the decision was handed down in December of 2019. It's an interesting decision. It involved a young man, a graduate of Maynooth University, who boarded, along with his brother, a Luas tram in Dublin. Not long afterwards, or at some point during the journey, two security guards got on and they asked the plaintiff in this case to produce tickets. The plaintiff did produce the tickets and had tickets himself and his brother, but accused the security guard of racially profile or slightly racially profiling. The security guard took exception to this and said that he didn't like his attitude, and there was a bit of an exchange, a bit of an argument as it were, or at least an exchange of views, and one of the security guards asked him to get off the Luas. The other security guard, however, very quickly countermanded this direction or this request. This is significant in the overall context of the case. The young men then were allowed to continue their journey. They had valid tickets, and when they got to the end of their journey, they went to make a complaint in the local Luas office, which was, as you might expect, closed. Between the jigs and the reels, however, defamation proceedings were brought, and the case first went to the Circuit Court and then it went to the High Court on appeal. The judges in the High Court then had to decide whether the young man was defamed or not, the plaintiff was defamed or not, by the Luas security guards, and had to decide then if he was defamed, what would the damages be, the compensatory damages. The judge accepted that the young man and his brother behaved perfectly well on the train or on the Luas, and there was no reason for him to be asked to get off. The court held that the security guards were perfectly entitled to ask for the production of the tickets. This was not defamatory, and the security guards would have had the benefit of qualified privilege in asking for the production of the tickets. But once the tickets were produced, at that stage the question of qualified privilege in terms of a defence to defamation went out the window, and that again is significant. So there was an argument between the security guards and the plaintiff and his brother. The plaintiff and his brother, according to the court, behaved perfectly well, and there was absolutely no reason why they would be asked to leave the Luas. In the heel of the hunt, the court decided that whilst the young men behaved correctly and there was a conflict of evidence and so on, the fact that the young man was subjected to being asked to get off the Luas, and there was an exchange of views that the other people in the carriage would draw one of two conclusions. Either one, that the young man didn't have a ticket, or two, he behaved in a way which would justify his being asked to leave the Luas. This was not the case, because the young man did have a ticket. So the High Court held that that act of itself was defamatory. insofar as there was absolutely no reason to ask him to get off to Luas. He behaved perfectly fine, there was no issue there, and he had a valid contract by reason of having purchased a ticket. So the fact that he was asked to get off was of itself defamatory. However, the fact that the other security guard countermanded this request very quickly meant that the defamation was fleeting or momentary. And on that basis, even though the High Court held that the evidence of the young men was perfectly acceptable and they had behaved correctly and they had valid tickets and they were defamed, the High Court held that the court could only justify nominal damages because of the very short nature of the defamation. The fact that the request to ask the young man to get off to Luas was quickly countermanded by the other security guard meant that any damage was very, very short-lived, and therefore the High Court awarded €500 in damages to the plaintiff. Clearly, if you go to the High Court with a defamation action and you're awarded €500 in damages, you are going to be in big difficulty in terms of your legal costs and so forth. However, in this case, I think that the court awarded the costs of bringing the proceedings to the plaintiff, but obviously the €500 by way of an award for defamation in the High Court would have to be considered to be disappointing. This case is evidence as well of what appears to be a trend in the High Court in the last year or two, where they seem to be arriving at more realistic, more reasonable awards for defamation. I've written a blog post about this particular case. It is involving, as I say, a Maynooth University graduate and Luas. It's on my website, businessandlegal.ie. The full decision is there. It's worth reading. As I say, the two things that I discovered was the question of qualified privilege, what is qualified privilege, and the other thing is, in arriving at whether somebody has been defamed or not, the High Court is obliged to look at all of the circumstances, all of the exchange, and it referred to a previous case involving Griffin and the Sunday newspapers versus Sunday newspapers in 2011, where it was held that a plaintiff cannot select an isolated passage or sentence in an article and complain of that alone if other parts of the article throw a different light on that passage. The real test is whether the result of the whole is calculated to injure the plaintiff's character. So that's basically saying that you can't pick an isolated sentence or word or phrase or whatever and pin your colours to the mast on that. The whole transaction must be looked at, and in this case the whole exchange between the security guards and the young man, the plaintiff and his brother, was looked at, and the court identified the particular instance of defamation where the young man was asked to get off to Luas. However, that was soon countermanded by the other security guard, and that's what the court is referring to there in terms of looking at the whole exchange and not relying on just one isolated incident and being able to pin your colours or hang your hat entirely on that one phrase or one sentence or one action, one interaction, in an interaction that may have occurred over a short period of time. Hope you find this video useful. If you do, you might give it a thumbs up down below, and you may be interested in subscribing to my YouTube channel. If you are, just hit the subscribe button down below, click on the bell, and you'll be notified when a new video comes out.